Australia Post has agreed to pay its former chief executive, Christine Holgate, $1 million as a termination payment after mediation before a former federal court judge. The federal government-owned company will also pay $100,000 towards Ms Holgate's legal costs, but she will not receive an apology from the company. Joydeep Hor is founder and managing principal with People and Culture Strategies, and he joins me now from Sydney. Mr Hor, this is your area of expertise. $1 million does seem like a big payout. How significant is it in Australian business terms?
Well, it's certainly a significant amount of money, Matt. But the reality of settlements of executive employment litigation is that typically when you're talking about someone at a CEO level or something thereabouts, you will be talking about a settlement that will be a multiple of their annual package. So in the grand scheme of things, $1 million is a reasonably hefty amount, but certainly there are plenty of examples of out-of-court settlements which are far in excess of that.
And Ms Holgate also gets $100,000 for her legal expenses. Is that likely to cover everything?
Well, it's hard to know exactly what her legal bill would have been. I would be surprised if $100,000 would be more than 20-30% of her overall legal costs. Maybe I'm being a bit unfair to her representatives, but it wouldn't be surprising if her legal costs were closer to $250,000.
Wow. Well, this whole saga is so strange because Australia Post has acknowledged in a statement they've lost an effective CEO. In your experience, is it odd that a company is threatened with legal action, settles for $1 million and says, actually, you know, they were effective at their job, wish you all the best?
I think the reality of settlements of these matters is that the financial compensation is one thing, and sure, the reimbursement of legal expenses or part thereof is another. But the most critical issue for a senior person, Christine Holgate would be no different. It's the damage to the reputation of that particular person. And what a person is often looking for in that particular situation is something that they can say came from their former employer, that stays on record permanently, that acknowledges that person didn't do anything wrong. And the best way that you go about communicating that a person didn't do anything wrong is actually saying something quite positive about that particular person. The interesting thing is, having been involved in countless number of these negotiations over many years, is that often the thing that takes the most amount of time to resolve in a negotiation is exactly these kinds of statements, the choice of words, often a lot of controversy around whether apologies will be provided. So when I read these kinds of things, I'm well aware that they would have been painstakingly negotiated, and I'm not suggesting that any of it is disingenuous, but there probably would have been a lot of thought given as to the precise words that we used in that circumstance.
So are you saying the money's the easy part, just saying sorry is the hard bit?
In many instances, it can be. And we see this a lot, particularly in cases of discrimination and sexual harassment, where the criticality of an apology or some statement of regret becomes a lot more important for a person who is suing. This, of course, was a very different type of case, but still had the same level of public attention and scrutiny. And I can completely understand why that vindication, that public expression of no wrongdoing was critically important.
Oh, sorry seems to be the hardest word. Well, Joydeep Hor, thank you so much for your time.
Thanks for having me.